We've been talking a lot about AI generated content and how it impacts us as entrepreneurs. And this week, we had a brand new conversation start inside of the space where certain entities are going to be digitally watermarking the content created through an AI generator. So, how is this going to impact us from a legal standpoint? Today, we're talking to everybody's favorite IP and entertainment lawyer, Tony, to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called the IP Professor that is dedicated to all things intellectual property.
Tony, we've been talking a lot about AI generated content, and recently they came out to say that certain entities are going to be digitally and visibly watermarking the content that AI generators are creating. This could be artwork, this could be text, and I want to talk a little bit about the legal ramifications of this. So, what are your thoughts on those digital watermarks?
So it's kind of interesting that that's a strategy, I guess if you want to call it that, that a lot of these companies are taking. I guess the only rationale that I could have for something like this is to alert people that this type of artwork was created by some type of artwork. I think a lot of people know Getty, for example, is known obviously for their great photo collection, but there's that very distinct watermark that they always have with the photographer's name, so on and so forth, to let you know that that belongs to Getty and a specific photographer was the one that shot that photograph. And from that point of view, that's more about at least asserting copyright ownership, letting you, the consumer, know that that came from Getty Images, that that photo was taken by a specific photographer. So at the end of the day, I can only think that the reason why some of these AI companies are starting to incorporate watermarks into their artwork is to let the world know that this is coming from a very specific AI generated software that made that artwork or that other copyrighted work, what have you. And, it's more of a calling card than anything else. Now, that said, I think that this all the more reinforces how that type of artwork or that type of AI generated copyrighted material is incapable of getting copyright protection, mainly because we've talked about it before in previous videos, but the U.S. Copyright Office has made it abundantly clear that anything that lacks human authorship is not going to get copyright registration. In fact, they just recently, this past week, ruled on a matter related to a graphic novel that a artist had generated that using AI artwork. It was through Midjourneys. And originally, the Copyright Office had granted copyright registration, but they realized that it was a mistake. So they reverted back. They basically put it through an appeals board, and they confirmed that it was incapable of getting copyright protection because it was generated by AI, and it lacks a human authorship requirement, aka it didn't have substantial human involvement. So all that to say, if there's artwork or other copyrighted material that contains this type of watermark that says this is generated by artificial intelligence, well, great, but it's just not going to get the copyright protection in the U.S. Copyright Office.
And we know that Google is going to be looking for things like those watermarks to understand if it's an AI generated piece of content that they can or should be sharing. When we talk about this, do you feel like looking at those future court cases, we're going to start to see mandates where these companies are going to have to be using these watermarks to let us know if something was created by a human or by artificial intelligence so that we have that organization when it comes to search engine things?
Yeah, I mean, and I'll even say not even just a mandate, but I could see a world where there's a contractual obligation, maybe if certain parties are being supplied, let's say copyrighted material or copyrighted material in air quotes there, certain materials that could be deemed copyright worthy. And part of an, maybe the contractual language lays out that, some type of representation and warranty clause that says that the materials being provided were not generated by an actual human author, but were rather created by artificial intelligence. Like this is coming to mind, let's say, when somebody enters into a work for hire agreement, and let's say they're asked to produce a specific work product on behalf of somebody else. Work for hire agreements, the way they function is that somebody is doing basically all the legwork on behalf of somebody else, but at the end of the delivery of that project, there's a conveyance of copyright ownership from the creator of that work to the person that ordered the work. So think of a situation where an artist, creates some type of artificial intelligence based artwork that was commissioned by somebody else. They're probably going to, or maybe the project, the work for hire said, the terms of the contract said something like, you're going to generate artwork on my behalf. The artist does create, they create artwork, but what if they created artwork using artificial intelligence? Now there's probably more of a contractual obligation for them to say, hey, I did what you asked, but I used artificial intelligence. I actually didn't expend energy or resources on my own. I didn't actually do the legwork. The artificial intelligence did it. So it's beyond maybe a mandate. I would say it's probably going to be more of a legal contractual issue at play here. And so that's going to add a massive wrinkle. But you're absolutely right, Cam. The way case law is going to lay out when it comes to AI and copyright, and then broadly speaking, the intellectual property space, we're just seeing it start. The Thaler case that just started in January in the District of Columbia District Court is going to be the first domino that's going to lead to this domino effect of what the IP community is going to view its stance on with respect to artificial intelligence.
So when it comes to these future watermarks that we are going to start to see, do you think it's relevant for us now to start disclosing this information just to kind of get ahead of that? Or do you think we can kind of hold off on that until we start to see some of these mandates?
I'm of the mindset that it's better to just disclose than keep it a secret. I think it's more of a matter of just good business practice and transparency than anything else. I think that, the essence of a contract is you want some type of mutual understanding or meeting of the minds. This is essentially the policy argument for a contract being entered into. And I'm speaking contracts in the proverbial sense, not necessarily written contracts, but even like a verbal agreement or something else. So when two parties agree to something and, somebody is delivering artificial intelligence based, artwork or any other generated copyrighted material, and they're not disclosing that this came from AI based systems, that could be a problem. That could almost interfere with the essence of the contract or the agreement right there. So whether that happens by way of the watermark, whether that happens by way of actually opening your mouth and actually saying it out loud, I think that's a sensible strategy. And listen, if the other party doesn't like that, it came from AI, then at least to move it along, go elsewhere. But I think the watermark system is probably a really, really efficient way of at least preventing some type of consumer confusion or creating some type of deception, if you will.
That makes a lot of sense. And as this continues to unfold, we will be doing future episodes all about that AI generated content and how you can be leveraging this inside of your business. So stay tuned and drop your questions down below. And if you've got questions right here and now that you need answered, you can always reach out to Tony on social media. So, Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at The IP Professor. And I've just launched a new podcast called NScene, an entertainment law podcast. You can check it out on all social media platforms at NScene Pod, and you can listen to it wherever you listen to podcasts.
How do you feel about digital watermarks on AI generated content? Do you think this is really going to bring to light the people who are actually doing the work and putting in the effort to the work that they're creating and putting out in the world? Do you think that this is going to hinder people who want to pass off some shadier practices? If you've got questions on the legal side of AI, now is the time to drop that down below for upcoming episodes with Tony, and hit that subscribe and notification bell for daily videos to help you level up inside of your entrepreneurial endeavors and navigate the world of social media so you can make more money online but spend less time doing it. I'll see you in the next episode.